Okay, we are back. It is 12:30. I'll just do a quick check to see if we have our quorum back for the meeting to carry on. Lee, are you here?
I'm here. Thank you.
Great, thanks. And Margaret?
Hi, I'm here.
Hi, thank you. Robert Boykin?
You know what? Robert sent me a message during the break saying he wasn't going to be able to come back.
Oh, okay. Canson, are you back? And Melanie has Melanie joined us in progress? Doesn't look like it. Tess, are you back?
Yes, I'm back. Thank you.
Okay. And hi, Kevin. See that you're here from Assembly-Member Medina's office.
Hi.
Hi. Canson, are you back yet? Not hearing Canson.
You know what? I think maybe he just got, I think I see him in the attendees. So.
Oh, did he get maybe disconnected?
Yeah,
put back up. Yeah. Yep, there he is. Canson, are you back and can you hear us?
Yeah, I'm back. I was locked.
I got it. Thank you very much. Appreciate it. And so do we continue to have a quorum with Melanie and Robert out?
Richie, can you speak to that?
We need 6 members to have a quorum.
Yeah, we currently have 5 of 7 voting members.
We're also not taking it, the rest of the day is just discussion. It's not any action items, so.
Correct.
Right, but in order to hold a meeting, we need 6. So even with discussion, we don't have a meeting without 6 members.
We may need to take a quick pause. This is, because I think we've had some different conclusions drawn more recently on that matter. Should we take a minute huddle?
You want to take, and you're going to do that on your end, Debbie? Do you want me just to hold?
Yeah, well, I'll connect with Christy.
Okay, great, thanks. Okay.
Hi, everyone.
Hello.
Sorry for that brief delay, but I know it's very important that we all make sure that we're doing things properly. Given that we're just moving forward with informational items and action is not expected to be taken or was not going to be sought, we're okay to continue the discussion for here. But just to be clear, even though these items that we're going to discuss for the next hour or so weren't agendized as discussion items anyway, but just to be crystal clear, if anyone, if any members wanted to decide to take action, that action would be needed. We would need to punt that until the next meeting when we did have a quorum. So, but we are free to move forward with hearing about and discussing the regulatory items.
Got it. Thank you very much. So on to agenda item 6 regarding regulatory proposals.
Great, and I will introduce David Dumble to walk us through item 6. Thank you.
Thank you. Hi, I'm David Dumble. I'm the Bureau's Legislation and Regulations Specialist. And today I'm going to walk through 3 regulatory proposals that the Bureau has been preparing and is almost ready to submit to Consumer Affairs for review. The first one should look familiar. It's the proposal for a date of closure, which was discussed at the February meeting. We've made substantial reorganization of the proposal, although relatively few substantive changes. Most of the changes have been in the structure of the organization. What we decided to do was delete part of the existing regulation and restructure it so that subdivisions A, B, and C deal with the closure plan that has to be submitted to the Bureau. A is the basic closure plan for all schools. B and C are the additional elements that are contingent on whether the school has any students who will not complete their program due to the closure and whether they have students who are receiving federal financial aid. Sections D, E, and F all deal with the mandatory written notice that has to be sent to students. And again, D is the basic requirements for all schools, and E and F are again contingent on whether a school has students that will not complete their program due to the closure and whether they have students receiving federal financial aid. So we think this structure will be more understandable and will clarify things much more than the previous structure. So let me just start by discussing 76240. The first thing we've done is delete the requirement that the plan be submitted under penalty of perjury. And then we added this first element that the closure plan will now request that the school be identified precisely with its name, school code, physical address, website, and whether what's being closed is a main, a branch, or a satellite. And we are also including a notice that if multiple locations are being closed, each location must submit a separate closure plan. Item number 2 has not been changed. Schools are still required to identify their date of closure, which will be the last date of instruction. We now have added a new number 3, which is a request that a contact person at the school be identified to communicate with during the closure process. This person may or may not be the same as the authorized school representative that is mentioned above. We just thought that in the circumstance of a school closing, it may be difficult to know who to contact. And so we want the school to identify somebody that we can communicate with assuredness. Number 4 hasn't changed that much. It looks like it has. Previously, we asked for all student level information that was required by the school to be kept under 76140. But instead of just saying that, we are now listing out every element we expect to be communicated. All these elements are required by 76140, although some of them are required by Ed Code 94900. But this is necessary because the current regulation just asks for a list of student names, and in order to contact these students, we need more information. We now have a new number 5, which requires a description of how the institution will maintain student records after closure, and a new number 6, which requires a written description of how the institution will provide written notice to students before closure. The new subdivision B is again about the closure plan, and it is the elements required for schools that have students that will not complete their program. And for these schools, they must also supply copies of any agreements for teach outs, transfers, and a plan for how they will do student refunds within 45 days. Subdivision C, again, refers to the closure plan and is for institutions that participate in federal financial aid and have students who receive such aid. And we want to know what arrangements they have made for the return of federal student financial program funds. Subdivision D, regarding the written notice, requires schools to inform students on how to contact the custodian of records if they want transcripts after closure, and also to provide information for contacting OSAR. Subdivision E is for schools that have students who will not be completing their programs, and they have to inform these students of the availability of teach outs, transfers, refunds, and information regarding STRIF. Lastly, under the new subdivision F, if the school has students that receive federal financial aid, then the written notice must include information on their rights under federal laws and regulations after closure. Lastly, there's a subdivision G, which was in the previous version that the school has to provide samples of their written notices to the Bureau. Although the one change here is that we did not provide a deadline previously. And we thought, since the school is in the process of going through closure, we should make it a very short deadline because they're closing. And so we now are requiring this to be sent to the Bureau within 5 days after the notice is sent to the students. That's the reorganized 76240. 76245 is pretty much the same as before. If the Bureau believes the institution has closed without giving us notice, we send a dated notice to the institution and inform them that they have 30 days to either confirm they are open or confirm that they have closed and to give us a date of closure. If they do not give us a date of, if they do not respond to this notice, then the Bureau will proceed to select a date of closure, and by operation of law, their approval to operate will terminate. We also will inform them that if they wish to appeal the date of closure selected, they will have 30 days after the deadline, or in other words, 60 days after the original notice, to contact the Bureau and request a hearing, either an informal or formal hearing, and appeal the decision to select a date of closure. The two processes that are available are consistent with Education Code 94940, which describes the way to appeal any adverse administrative action, which this would be. Are there any questions about our date of closure proposal?
Advisory Committee discussion on the date of closure proposal.
This is Margaret. I have some questions and comments on 76240. Maybe you can just explain this. All institutions, including those exempt from Bureau regulation pursuant to the code, shall do the following. Who are you getting to that in that sentence?
That this is a notice that any institution that is exempt, that they've got an approved verification of exempt status, or they just are operating as exempt, they still have to follow this procedure under the Education Code, even though they're exempt from Bureau oversight.
Can you give me that? Do you happen to have that section offhand?
Offhand, I don't have it.
That's okay. All right, that's fine.
Keep going. I'll get it to you, Margaret, in just a second. While you and Dave keep.
In that same section A1, I like the change that they have to have a separate plan for each location, because that often can get confusing when there's different ones. Let's see, this would be 4. So that's 76240A4. A list of students who are enrolled at any time during the time period prior to closure as provided by is that 120 days? Is that what you're getting to there?
Yes, that is 120 days. Currently, we thought by citing the Education Code section, if that were ever to change, we would not need to change this regulation in response.
Got it. I was wondering. It might be useful. Well, I don't know, maybe you can't, but for regulations, just for the ease of people using it, you might put in there as of, such and such 2023, that is 120 days, something like that, just so it's easier for people to not have to figure out what you're talking about. But, I don't know if you can do that. I guess this would be, this is on your page 90. So I guess this is number 6 under, I don't know what that's under, A or B. You found which one I am, the new number 6, a written description of how the school will notify the students. Do you find that?
Yes.
Okay. You have, after they've already sent notice, they have to provide a copy of that notice to the Bureau. But I think is their plan, they should also have to provide you a sample of their intended notice, so that before they send it out if it's proper. So that if they've got something wrong, you can let them know, no, you need to change this. So in addition to a description of how and a copy of the proposed notice, I think would be helpful to add there. In B1, this is just a minor grammatical thing. A copy of any written agreements with other institutions providing teach outs, if applicable. Presumably it's applicable if they have any, and if they don't have any, it's not applicable. So I don't think you need to say if applicable. If you say any, then if they have any, they do it, and if they don't, they don't. So maybe just a redundancy. Number 3, also B3, arrangements for making refunds for students who will not complete and who also choose not to participate. The student has a choice to attempt to teach out and then decide not to follow through with it and still get a refund. And so it seems to me that they should have to have arrangements for that possibility included here. In C, I guess it's probably clear enough. I just wondered if when you say arrangements to return federal student financial program funds, does that mean to the Department of Education or to the student, or could be either?
My understanding that is to the Department of Education.
Okay. If that's the case, I probably would specify that, but it's probably not necessary. So I just, and then in E, the same point, for all students who will not complete the notice of closure, including information about the availability of teach out, and the student's right to refuse to participate in a teach out and to instead obtain a refund, and the other alternative to participate in a teach out but not complete it and receive or obtain a refund. That's an eventuality that should be covered here also. And that's under, I think that's under 94923B2A is where that's explained that you are entitled to a refund even if you start a teach out if you don't complete it. But I think that should be part of what they have to explain to the student. And then 76245. In the first sentence, if the Bureau believes that an institution has closed without identifying a date of closure, I think it would be better if it said without notifying the Bureau of its date of closure. Because they may identify one internally but not tell you about it. And what you're really getting at is they didn't let you know the date of closure. And in B, I appreciate the change there so that it's clear and doesn't penalize students who might be trying to get a refund to have some later date for it just because the school didn't respond. Thanks very much.
Okay, you're welcome.
Margaret, just to follow up on your question before, it is California Education Code 94874.5 that says an institution that's otherwise exempt from this chapter shall still comply with section 94927.5, which is requirements around provision of notices and records around closures.
Can you give me that section again?
Sure. The first one was 94874.5, and the second is 94927.5.
I think you might want to add exempt under and then reference the statute because those are specific schools that are referenced as being exempt, but I would refer it back to under the California Education Code such and such, or just the California Education or article, whatever it is of the California Education Code.
Just for clarification, Ms. Ryder, anything that's not underlined is existing regulation and has already been adopted by the Bureau and approved by the Office of Administrative Law. So we try to stay consistent with the naming conventions we use in regulations. And so the reason why it says of the code is because it's defined in the definition section that code refers to California Education Code. So, unless we absolutely have to make a clarifying change, I would recommend against that because
that's fine.
If additional workload for the Bureau.
That's fine. If code has already been identified as education code elsewhere, then that's probably okay. Thanks.
Any other committee discussion on 6A?
This is Lee. I had just two comments. One is under A3, and I don't know if it actually would go under A3, but that's the one that requires the contact information for who will be the institution's contact person for purposes of the closure process. I just had a thought that it might help to have a requirement that if the contact information were to change, that they also provide updated information. I don't know that that needs to be in here, but I just, there's times when, that might change and it might be more than, a month or two out and they forget to update. So having some kind of requirement of either updating or that information will stay current for a year or something like that could be helpful. And then under kind of the DEF sections that requires the written notice of closure to the students, I was wondering, and this is something that I'm kind of proposing, I'm not sure that it's actually a request yet. I'm interested in other feedback from other committee members if they have any, if it makes sense for the institution to also include the date of last instruction in that notice, assuming that they've identified it, because I think if that's what was discussed later as the kind of the idea for the date of closure, I think it could be helpful to communicate that to the students. And that was all that I had. And I just want to reiterate, I really appreciate having that chart at the beginning of the regulations section. It's so helpful to track where we are and where we've come from and all of that. So just want to say that that's very helpful.
I agree with that second comment particularly. And I would say that, I just lost my train of thought. Sorry. Never mind, whatever it was, it disappeared.
And I'm going to hold public comment to the entirety of agenda item 6. So we don't have to go back 3 times for that. And we will, though, as we have David stop for committee discussion after A, B, and C. And then we'll do an inclusive public comment. So
I realized what I was going to say to Lee's comment. I would specify the date of closure which the school has identified to the Bureau, so that you don't have the Bureau putting one thing down on the notice to the students and telling the Bureau something different.
Okay, so let's go ahead and move on to 6B.
All right. Item 6B deals with public institutions. As you may be aware that in 2022, legislation was passed, Education Code 94949.8, which authorizes the Bureau to approve for operation in California public out-of-state institutions that have a physical presence in the state. And 94949.8C specifically directs the Bureau to amend any regulations that conflict with this section. After reviewing the Bureau's regulations, we find most of them are flexible enough to apply to public institutions, with one exception, and that is 75020. 75020 is the regulation that authorizes the Bureau to issue citations for any acts in violation of either the Private Post-Secondary Education Act or any regulations adopted by the Bureau under the Act. Unfortunately, the regulation only authorizes the Bureau to issue citations to, quote, private post-secondary institutions. In order to make sure the Bureau has the authority to oversee public institutions effectively, the Bureau is proposing to delete the word private in subdivisions A and B of 75020. The Bureau does not anticipate issuing any citations to public institutions, but we feel this change is necessary to fulfill the legislative mandate and to amend regulations in conflict with Education Code 94949.8. Are there any questions?
I'm wondering if that, by just saying post-secondary education, post-secondary institutions, if that doesn't make it overly broad. Because wouldn't this then allow the Bureau to apply it to any post-secondary institution in the state?
Well, presumably we would only have authority over institutions that we have authority to oversee, which would be private post-secondary education institutions, and now public institutions that are out of state with a physical presence. So I don't think it would expand the Bureau's authority over the statutory definition of the Bureau's authority.
Maybe not, but I think it's ambiguous, and it would be useful to maybe identify it against approved post-secondary institutions.
We can take a look at that because we also don't want to make it too narrow. So I think your point is well taken. We'll
Yeah,
take a
it
look
may
at
not be necessary.
Any other discussion on
this-
6B?
Sorry, this is council. I know your regulations council is listening, but I do believe that the regulations council hasn't seen this proposal yet. So we will be taking back any feedback you have and discussing with the bureau chief at another date, and we'll let you know. Thank you.
Yeah, the kickoff meeting for this proposal has been scheduled for next week. And at that point, we will be presenting it to our regulatory attorney and others in consumer affairs before we submit it to them to get some preliminary feedback. That has been scheduled for next week, so no one at DCA has had this vetted by them at this time.
Any other discussion from the committee on 6B?
I have one other question, and I realize this is not in language you're changing, but while you're changing the regulation, you might want to take a look at this. And I don't know the answer for sure. On D, so that's 75020D, served on the site of an institution or person, certified and regular mail at the address of record on file with the Bureau. Are there not individuals that you could cite who don't necessarily have an address on record with the Bureau? And if, I don't know the answer, but if there are individuals you could cite who don't have an address registered with the Bureau, then add something about, or the individual's address or something like that. But I don't know whether every single person that you might be able to cite actually has an address with the Bureau.
Take a look at that.
Very good. Moving on to 6C.
Right, this deals with signature requirements on Bureau forms. For some time, the Bureau has been considering making changes to the required signatures on the Bureau's forms. This was discussed at the advisory committee meeting on February 23rd, 2022. And at the time, we noted that some of the signature requirements can be burdensome, especially the requirement that the governing board of a nonprofit corporation, every member of the governing board has to sign an application. There appears to be no reason for distinguishing between nonprofit and for-profit corporations. There appears to be no reason for signatories of a substantive change application to meet the same standards as signatories of an application for approval to operate. And lastly, the Bureau's newfound authority over out-of-state public institutions means we have a new business organization, public institutions, that we have to consider who we want to have responsible for signing applications submitted to the Bureau. For these reasons, the Bureau is going to undertake to change the signature requirements in one regulatory package on 10 of its 14 existing forms. One of the Bureau's forms, out-of-state registration, currently just requires an authorized signatory, so that does not need addressing. 3 of the other forms will be dealt with in other regulatory packages that will be going to DCA this year. The regulation is fairly straightforward as far as drafting. We simply are going to the regulatory sections that regard those forms and delete the current signature requirements and replace them with what is described in the memo that is in the materials. And then we also will have to go through all the forms and make the subsequent changes on the forms. The new signature requirements will be as follows. For an approval to operate or a renewal of an approval to operate, if the institution is a sole proprietor, is owned by a group of individuals, or is owned by a partnership, the application must be signed by either each owner or by each partner in the partnership. If it is owned by a corporation or is a public institution, then it must be signed by either the chief executive officer or the president of the corporation or institution. For substantive change applications, the signing requirements are the same, except that for corporations or public institutions, the chief executive officer or president may delegate the ability to sign to someone who manages institutional affairs for the corporation. Are there any questions?
A couple of things. I didn't see it here, but maybe it's somewhere else, or maybe it's here and I missed it. But usually when you're asked to give a digital signature, you are asked to agree that your digital signature, you are signing digitally, which is effective as any other signature you would give. And I just wonder if you might want to have legal take a look at that and see whether it'd be useful to have a box to check or something where people say, yes, I understand that. You know, this is my signature. The second thing is in the memo, you talk about why you might or might not need to have these other people sign. And I think that one thing that's not addressed is that some of these are signed under penalty of perjury. And apart from whatever actions you might bring against people for misleading statements or fraud or whatever, that separate violation of a penalty of perjury is a useful tool for prosecutors because it's, fairly straightforward. We have a library with 10,000 volumes, yes or no, or things like that. And so I am particularly concerned about two of these. If it is a private corporation where you have ownership by somebody with at least 25% of the company, they could very well have someone who is in effect a flunky type person who is told to sign things that are not true and not sign them themselves. And then the flunky person is, subject to prosecution, but the person perpetrating the crime is not. So I think with companies where you have ownership that high of at least 25%, that those persons should also be signing. And also then with the substantive change, the same issue, it really should be the chief executive, not somebody that they designate. They can designate somebody, tell them to sign it, that it's all correct. And in fact, they don't know whether it is or not, but they can't really maybe be subject to perjury because they don't knowingly do it. But the one who actually caused the problem is not required to sign under penalty of perjury. So I would say those two things should be continued in place.
As far as the signatory by an owner with 25%, the new requirement is that all owners or partners have to sign the application. So that would apply to owners with more than 25%. It would apply to owners with a smaller stake in the institution.
I see how you're doing that. Okay. But now you say, but you say if the institution is incorporated, so you're not applying it to the incorporation it's under a separate subsection.
Yeah, well, something that's incorporated, the purpose of incorporation is to legally separate the ownership from the individuals into a new legal entity. So that's why we're having a different standard for corporations, whether they be for-profit or nonprofit.
Right, but nonprofit corporations, they're not owned by anybody other than their nonprofit, whereas the corporation is. So think about a mom and pop corporation in effect, or a family corporation where everybody owns 25%, but none of them are signing anything and they're running a fraud. And I think that they would be allowed to escape by this.
So real quick, Christy Shield again. So I think these are all great points, and we're certainly going to be looking at these proposals. The Regulations Council will be taking his look at it, and others will be looking at it. I do want to reiterate, though, that it's common practice for agencies in this department to have a corporation designate or authorize a representative to bind the corporation and sign the app. And so it doesn't relieve the corporation of the liability for anything that's been signed incorrectly or falsely attested to. You can still hold the corporation liable even if the flunky, as you've indicated, signs it, because we put on there they have to have the authority to bind the corporation and sign it. So someone gave them that authority, but regardless, it binds the corporation. They're under agency principle, and agency legal theories of liability would be chargeable just as well as the person that signed it from my perspective. So I think that, we certainly can take a look at tightening up the language, but I don't think that the Bureau's proposal is problematic from a legal perspective in terms of holding the institution or applicant liable, in my view.
Yeah, right. I'm not concerned about, I understand what you're saying about you hold the corporation liable. So you have a mom and pop owner of a closed corporation. They each own 50%, or you have a family and they each own 25% or 30%. The corporation has virtually no assets. It's held liable, but there's nothing that you can gain from them to get back to students. The individuals who are perpetrating the fraud, these closed corporation members, the family members, are not liable. And so that's why it's important to have them sign under penalty of perjury. So that's something I've seen that in cases that I've prosecuted, and you don't want to be in a situation where fine, you have a judgment against an empty corporation.
Right. I mean, there's other legal theories that the Attorney General's office usually pursues in those cases, and alter ego is one of them.
Right.
But in any
those
event,
those are not as easy.
Right, but I mean, at the end of the day, I think the issue is, will the signature bind the corporation who is the applicant? And I think the answer is yes. That's really all the Bureau is doing right now. As far as the other issues, we can handle those separately in enforcement, I believe. But in terms of just deciding who can legally sign this on behalf of the corporation, that's the standard they're trying to address.
Right.
So it's just like, who can bind them to whatever's been stated on the application. That's the proposal that's in front of us. There could be other issues, like you've indicated, related to that. But again, I believe, in my experience in the department, that is a common way for a corporation to submit an application. They authorize a representative, or they designate a representative to sign on their behalf and bind them legally. And we say that in the certification typically. So we can take a look at that and make sure it's tied up as tight as it can be from your perspective, I think. But I think that the proposal that the Bureau is putting forward is consistent with licensing processes I've seen with other agencies.
Just one final comment on that. And of course, as you know, throwing alter ego is not an easy process. It's a much more
I know.
And complex.
I'm not trying to. Yeah, exactly. You're right.
So, and what we're trying to do is, not allow by people to get around the requirements by fraud. And we do have those nowadays we have lots of major corporations where everybody owes, 5% or less, but we also have the mom and pop type where they are really, we call it a corporation, but in fact it's, a couple or two or three people running the thing. And it is important. The priority here in this statute is to protect the public. That's the first priority of the Bureau above everything else. So I think that we want to make sure that we're not creating a loophole for those kind of fraudulent companies that are out there.
I think within the current structure of the Reform Act and the Education Code, the way it's currently written, the proposal the Bureau is putting forward is defensible. If you wanted to look at drilling down behind corporate veil, so to speak, and structure, that might be something you'd want to discuss in as potential legislative changes. But for now, this is the, I think we're required in regulation to pick the least restrictive alternative in implementation. And it is the least restrictive, but effective option for implementing a signature requirement for a corporate entity, whether they're large or small. So I think that's one thing we have to defend when we're deciding to adopt regulatory language. And so currently, I think that proposal the staff are putting forward, again, the Bureau Chief can always reconsider, is legally defensible and the least restrictive alternative for implementation for a corporation.
Well, what I'm proposing would also, of course, also be legally appropriate and would carry out the primary goal. The statute is written so the primary goal is to protect the public. And so the fact that it may not be the least onerous is not to be considered a priority over what's the most to protect the public. So what I'm proposing, I think, would also be legally defensible, but not only legally defensible, but in consistent with the primary goal. So I hope the Bureau will take a good look at that, because otherwise, I mean, it's already in regulation, something much more restrictive. So
Right.
certainly that was approved and is current now. And maybe if we can't come up with something that is going to protect the public, then maybe we should just leave the regulation as is.
I think what I'm hearing too is, obviously on this one, we didn't just put forward a proposal. We have a whole memo explaining kind of some of our thinking. I think one of the takeaways that I'm hearing from Margaret's comments are that maybe there's some scenarios we haven't quite fully captured or haven't fully considered. So it's helpful, Margaret, to hear those very specific examples, and we will definitely take that back. And like Christy said, we'll kind of huddle and figure out where we're going to go from here. So this is very, very helpful. Thank you.
Very good. Well, now at this time, not hearing any more feedback on 6A, B, or C from the committee, we'll open for public comment. David, could you help with that?
We are now open for public comment on A, B, and C. If you would like to make a comment, please type the word comment into the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand. We will call on people in the order we have requests. And our first request comes from Bree Meinberg. Hold on just a moment, Bree. We're going to send you a request to unmute your microphone. You'll be given 3 minutes and a warning at 2 minutes and 30 seconds.
Understood. I just wanted to make a comment regarding the identification of the date of closure. Understanding that the proposed language stipulates the last day of instruction will be established as the closure date, I would like to suggest that the Bureau considering allowing a more broad criteria for establishing that closure date. For example, for institutions with a hybrid delivery model or a large volume of online instruction, the instruction may continue through a different modality. Additionally, there may be institutions that cease instruction but continue to offer administrative and advising services for a period after the last class is held. So I just would like to propose that the Bureau consider these factors when establishing the criteria for the closure date. Thank you.
Thank you. And our next request comes from Thomas Vu. Hold on, Thomas. We're going to send you a request to unmute your microphone.
Hi, can everyone hear me okay?
Yes, go ahead, please.
Great, thank you so much for this opportunity. My name's Tom Vu. I am Vice President for Policy at AICCU. We are the organizational voice for independent nonprofit colleges and universities in California. First, thank you to Debbie and to the Bureau staff for your work on bringing forward the proposed changes on the signature requirements. We are definitely supportive of the proposed changes as they are written in the agenda for the signature requirements. From what little I've heard of from in the discussion, it seems like there may be some changes to that. So we look forward to seeing what may come out of today's discussion. But just to summarize very quickly, the proposed changes modernize the process and also creates much more efficiency and eliminates unnecessary complexity for both the institution and for the Bureau. In the last couple of years, a handful of our members had to go through this process, but had some challenges gathering all the signatures. Mainly, one of the some of the board members were outside the country, or another was in the hospital with an illness, so it was very challenging and unnecessarily so to receive this or to go through this process. So looking forward to seeing what comes out of this, and looking forward to working with Debbie and the crew over at the Bureau on this. Thank you very much.
Thank you. And with that, there are no more requests for public comment at the moment.
Excellent. Thank you. we will carry on to agenda item 7 and the complex situation with applications for exempt status. Debbie, you want to walk us through that memo and the discussion questions?
Perfect, absolutely. And it's going to be myself and Ebony Santee as well. I'll just, and hopefully folks have had a chance to read the memo, so we're not going to go through every item in there in detail. Similar to some of the other proposals we've talked about, I guess we were just talking about with the signature requirements, how this is actually kind of a continued conversation from prior meetings. I believe it was back in October of 2021 when we presented to the committee a draft new form for a verification of exempt status. And we keep saying we're going to talk about that at a future meeting. And the reality is, as we've been working on that internally, we've continued to appreciate the complexities associated with determining exemptions and verifying exemptions and some of the challenges with the forms. So, which is why we, instead of presenting to you another draft form, we really wanted to present to you a set of items for discussion to get input and feedback on factors we might want to consider or directions we might want to go. This is, of course, driven by this need to update our form, but I do want to make sure it's very clear throughout this conversation that it's not just about our licensing unit and processing a form. Exemptions are something that's very related to all of our operational units. Investigations, you will recall from some of Daniel's charts, some of the discipline around unapproved activity and complaints, and that's something that our investigations team is consistently looking at too. Is a school exempt, or does it require our approval to operate? So how we operationalize those are bureau-wide priorities. The exemptions themselves are in statute. They are mostly in section California Education Code 94874, but also there's a separate one in 94947. Generally speaking, we've kind of categorized in this memo exempt institutions as ones being seen, or these exempt categories as ones being seen as low risk. Again, those are our words, not the words of the legislature, but just in terms of an attempt to understand conceptually what exemptions are all about. Many exemptions are granted based on the approval or oversight of another entity, or the fact that they charge students very little. So not seen as huge consumer risks. Our verification of exempt status application is also driven by the statute. The statute directs us to have a process through which an institution may verify their exemption. That it's a voluntary process. So, in terms of how many institutions are exempt in the state, we wouldn't know. We would be able to answer questions about how many people have a verified exemption, but not how many exempt institutions there were, because a lot of them don't come to us. Some of the ones that do come to us are ones that do need some sort of authorization from us or verification from us that they are in good standing with the Bureau. They're either approved or they have a verified exemption, and typically that is to receive some other form of government benefits. So those are very understandable types of exemptions for us. In a different category, we have increasingly seen institutions that aren't receiving government aid, but are very prominently listing their exempt status, say on their website, including it in marketing materials or YouTube advertisements. The fact that they're exempt, in those cases, it's not quite clear why they do that, but it does seem to suggest that entities are using the fact of their exemption as a way to claim legitimacy, that a government regulator has declared them exempt or low risk, and that they're kind of in good standing. So it makes it all the more incumbent on us to consider those applications very seriously, to make sure that we're doing our best we can within the charges that we're given. So our memo mentions that we do receive more of this type of application than any other type at the Bureau. I know there's a set of institutions that people probably think about when they think about exempt institutions, but it's a lot more than any other type of application that we get. Our memo does outline a number of example application scenarios. Want to just reiterate, of course, those are not exactly any one particular institution or application that we've gotten. They're really kind of amalgamations of of common scenarios we see. Thought that might just help give the advisory committee a bit more of a idea or a vision of what we're trying to tackle when these applications come into us. As we're thinking, of course, about these challenges and the workload associated with them, of course, the other important component of that is how much time, how much resources should we dedicate to this? This happens to be our only application for which our fee is set in regulation. Under the understanding that these exempt schools are kind of seen as low risk schools, we've historically set up a process that is effectively a low risk process. It's a $250 application, which after you account for, just kind of touching paper, some amount of staff time to just, receive an application and file an application, it ends up with about an hour and a half of analyst time. So it's something we're constantly thinking about how to use that time. Is that enough? And how should we be strengthening our approach to handling these exemption applications? So with that, I'm going to pause for discussion. Like I said, Ebony Santee is kind of co-leading this discussion with me. I wanted to pause. We do have a number of discussion questions in the memo, but also just wanted to open it up to see if members had any thoughts, questions, comments, or anything else to add before we just dived into discussion questions.
I have some thoughts and comments, but I don't know whether it's more helpful to just where exactly to put them in. I made some notes before the questions, so maybe it makes sense to point out where I made those notes. I can do that, or I can just wait and go through the question.
Are most of them your notes associated with the questions, Margaret?
They're mostly associated with the things that are said in the memo. Points made in the memo. I'm sort of responding to the examples.
Ebony, what do you think?
I'm good with starting there. Because it could be a nice jump off point for the rest of the discussion questions.
Okay, I can do that. One question, or let's see, one of them I'm looking at is first of all, on bona fide or sponsored. Bona fide does have a particular legal meaning. It basically means good faith. So I think in the current statute, you could, in essence, if you find some of these that are not really legitimate organizations, or what appear not to be legitimate organizations, you could deal with them as unlicensed schools. But obviously, it would be helpful to you if you had more language. And I think the example that you put in here from Colorado has some very good language that might be very helpful. And I'm not sure that all of it could fit under our statute, but I think it's got some good language. But I think I would sort of couch it with must be in good faith, and then go on to include the specifics, so that regardless of the specifics, there'll be some, maybe you have a good faith catch-all, so that if it doesn't, so that you're sure that you get it through that if necessary. On the challenge of these low-cost programs, where they're basically stacking courses. I think we ought to be talking about maybe should we come up with some statutory revision to help there. That issue also comes up when schools are supposed to disclose their cost of the program, and so they have a bunch of 1-year programs. But if you want to get a BA, it's really 4 programs, but they're not disclosing that as their program cost. So in comparison to other schools, they look cheap. So I think that whole issue of program stacking is something that really needs to be looked at, and maybe needs to be looked at with a change of statute. And then on your institution D example, I would try to figure out what they're doing. It seems like something really bogus is going on there, but I don't know quite what it is. So anyway, and then I would just say and then the rest of my comment was on the discussion questions. So thanks.
Thank you for that, Margaret. Just a little more context probably for the institutions in D. A lot of times, potentially schools might start as an exempt institution because they have a lower cost program and maybe another agency solely oversees that, and those regulations don't require bureau approval. So they might start and then in the meantime may want to create or offer other types of programs or other cost points, and so they would go for that approval. Often that's our question with what's happening or what's going on at those institutions. So we definitely do dig into those, but it can be difficult if it is the same owner as well. But we definitely have times really looking at faculty, use of space, the viability of how many students can be enrolled and complete a program successfully. So it can become an issue because we don't specifically speak to more than one institution operating at the same location. So those are all definitely good points for us to think about. So jumping into our discussion questions, and I will just kind of go down the list, and if you have anything, please definitely chime in. I don't know if you all have had a chance to look at the verification of exempt status application, but that is on our website with all of our other licensing applications. So this question directly is, what types of information submitted in the verification of exempt status application should routinely be requested, and what information should routinely be tracked by the Bureau for ease of future reference? It is quite a scaled down application comparative to a lot of our other apps. We are looking at owner information, location, but really specifically minimal items when it comes to each of those particular exemptions. So just some ideas if we should be doing more and what some of those things would be, if you had any input on that.
This is Lee. I have a few ideas. I will say I haven't looked at the application, so I need to. What I'm planning to do is do a little more comparison afterwards, and then submit some written comments afterwards to be a little more clear and complete. But I think from what the report and the memo identifies that it could be helpful to include some requests for information of the items that you're seeing that are problematic. So, reporting not only the name of the institution, but any institution that has substantial control, which, obviously we'd have to define whatever that means, but, some information about the proposed programs, the ability to stack programs, some of those kinds of things. I mean, I don't want to make it a 40-page application because that also doesn't help you guys, but maybe providing some of the information that it seems like you guys are discovering through investigation might be helpful in terms of the time that you're spending on the application and being able to do a verification as opposed to, more of a full-scale investigation. But I will provide some additional details separately.
Thank you.
Yeah, just to add to that, I would say that knowing what your specific problem areas are, you can reverse engineer what needs to be added to the application. So as you look at the body of work that your people have done in an investigation, and the ones that you think like, wow, this is weird, or this took me a lot of hours because I was trying to figure this thing out, and then back from what that issue was, and say, okay, so what question would I ask the application that would have simplified my investigation so I wouldn't have to dig as hard. One particular I noticed, I reviewed the application, which I would say is not super light. Like there is a lot of information there. It's, a substantive 5 pages. Would be related to what other institutions do you own any does this same owner operate any institutions that are not exempt, right? Like trying to get at those relationships. That was just the one that jumped out at me, but you guys would surely come up with better ideas looking at your investigation material.
Yeah, Margaret, I didn't look at the, I'm sorry, were you gonna, go ahead.
I was just going to say I really like Lee's comments as well and agree.
Also, and I also have not looked carefully at the application, so I need to, do a little more homework and then get back to you on that. But it occurs to me one thing that might be worth doing, if I presume maybe you've already done this, is look at some organizations that are legitimate, like, trade unions that have been around a while, or different kind of organizations like that that do have programs for their members, and look at what they have that makes them legit. I think some of the suggestions in the Colorado statute are good, but just for example, one example would be, how long have you been an organization? And, maybe what percentage of your members each year participates in educational programs, things like that, that would, and what are the other activities that you do besides offer these programs to your members? Something to give you a feel whether there's a real organization there. And I don't have any more specifics, but that's kind of a way I might approach it, would be to look at some that are obviously legit.
Great, thank you. Moving on, how should the Bureau handle applications from entities that purport to be a post-secondary educational institution but may not be? What aspects of an application would signal cause for concern, or what levels of documentation and investigation should be required? So just for a bit of clarification, potentially we might have an institution or a contact from someone who says, we don't charge any tuition, or we only charge, $1 or something, or everything's on scholarship, or do we need to apply, or can we be exempt? Or, how do we fit into your oversight if not? And so oftentimes, if they don't meet the definition of private post-secondary education, or if it looks like maybe it's a business to business or something to that nature, we often say that you are not required to be approved and you can go on your way. Or sometimes they do want or need some type of verification. So I guess this question is kind of just some feedback on that, how to handle that or continue as we do.
Can you describe more what you mean by purports to be an educational institution?
Well, similar to like I said, they might have courses for, some might be have contracts with a specific entity. And so we might look at that as a business to business, because it wouldn't be like open to the public per se. So having to explain what that means, or by definition, a private post-secondary institution has institutional charges, but schools might come to us and say, we don't charge anything, or everything, a student can get a scholarship through our endowment agency or so forth. So are we a school or not? Even if they do offer programs to the public or of various types. So those types of situations.
Can I just to give a very simple example? If someone sends you a website that is, John Smith gets a domain name, John Smith University, and that web page says that they offer bachelor's, master's, and doctoral degrees in biblical studies at a charge of whatever it is, $10,000. How do you know that that is more than a website? How do you know that John Smith University is an actual university versus a website and with a minimal registration with the state? And does it matter?
I was wondering, this is Lee, sorry. Along the lines of what Chair Holt said earlier, using some of the information that the Bureau is getting from the complaints for exempt institutions and identifying like what are the the top complaints that come in. I know those aren't right now necessarily processed by the Bureau, so I don't even know if anything is done to track those and like what types of complaints those might be. But it seems like that might be one way to do it, for both discussion items 1 and 2, is looking at, kind of what are the biggest problems that exist. I don't know what the internal process is right now for reviewing exempt applications, other than that it's more than 1.5 hours generally. But it seems that maybe there could be sort of like that checklist, and this probably exists already, but like an internal sort of conflict check to using the data that's provided, and reviewing the website. I don't know honestly how you answer your question, Debbie, of like proving that a website is more than just a website. I don't know. That part is really hard when you don't have the oversight to be able to do an inspection or physically visit or audit a class. Other than, requiring there to be some entity that provides oversight, but that I think would have to be a statutory change.
This is Margaret. I don't know how much you can require, but it would certainly be good if you could get a hold of students and find out what they have to say. And I don't know whether you could require them to provide, a random sampling of their students for such and such time period. But, on a website, it seems to me that you can go a little deeper and then go to things that they mention. So they mention where their location is. You could have somebody go to the location. I mean, they don't have to let them in necessarily. They don't have to go in, but they could see if it's a PO box or if there are actual students there, if it's not an online school, of course. And I think also you could have gradations in how much information you need, presumably depending on things like, if an organization has been existed in California for 20 years or 25 years, maybe you have a lower level of what you require from them and how much time you need to spend on it. Maybe you require, maybe you can ask for or statements from people in the industry as to, or the field as to what they know about this organization. I don't know. I mean, these are really good and really good, tough questions.
Yeah, they are really difficult and thoughtful questions. I appreciate you bring them. One idea that was sparked is you already have a investigation and discipline unit that looks for unlicensed activity. You're already looking for schools that are operating in that way. And so this, not to be cynical, but you could view almost a application for verification of exempt status as a lead and so you would follow the same process that you would for trying to find unlicensed activity. It's almost like somebody's raising their hand and so if you're saying, hey, is this a real school or not? I think you already have the mechanism for that in your compliance division, right? Like with the people that try to investigate and identify unlicensed schools.
Mm-hmm. So I think the thinking, just to make sure I'm understanding this, because we would, like my example of the biblical studies, John Smith University, that would seemingly qualify for exemption under the religious exemption. But I think so what our investigation would really be, do we want to give the owner of this website a piece of paper that says, yes, you're exempt? Or do we decline to give that piece of paper to the owner of this website? I think that's what we're talking about. Is that correct?
I would think you would have an onus to confirm the exemption. So you therefore would require an investigation to determine that.
And maybe, sorry.
Oh, I'm sorry, just real quick. Actually, it is a timely issue. I actually have personally a hard stop at 2:00. I have to leave. And so Lee, I'll hand things over to you as vice chair to continue from that point. And I apologize, Debbie, and Ebony for putting out of order here, but I have a couple other thoughts real quick that I could share in my so we'll jump around just a touch for that. I think the most dangerous of the issues mentioned was the stackable. And I wholly concur with Margaret that that may need a statutory fix, but that is very dangerous to have a price exemption that people could, nefarious owners of schools or people trying to operate a school could say, hey, technically this meets the definition, but practically it does not. And if you don't have the statutory authority to enforce that, then that's a high risk, high importance item to pursue. And that very much sounds like somebody gaming the system. Yes, I think to questions 4 and 5, you should pursue regulatory definition or a more robust definition of sponsored and bona fide. I think those are important. And then the last point is you give great examples. I have no idea what the volume of those various examples is, but as far as obviously for your prioritizing which of these seem to be most prone to abuse, some of them to me struck me as maybe abstract and academic, like, wow, that is a real head scratcher. But if it doesn't happen a whole lot, then I maybe would not spend as much time, worrying about it. So thinking practically in terms of where is the greatest risk to California consumers and to focus those efforts.
That was something that came up for me too, was thinking about how often and go from there with the bandwidth that you have with the resources on staff.
Yeah. And with that, I'll go ahead and drop off and apologize that I have to leave. And thank you, Lee, for carrying it on from here. Bye-bye.
No problem. All right. First day on the job and I'm already in charge. I was just going to add in, and then other folks feel free to continue commenting. I mean, if what the question is too is that if, after some reasonable amount of investigation, the Bureau can't determine that they actually qualify for the exemption, then, I mean, I think the argument would be that they can deny it. But I don't know if that's, like, I guess it's a little unclear, like, how much leeway or power the Bureau is given to be able to deny. But if you're looking and you see a website and there's no ability, the applicant doesn't provide enough information to verify anything else about it, I think that is one solution, is for the Bureau to say, if you can't give me anything else, then we can't approve the verification. We can't verify the exempt status.
And just to add to that, and part of number 3 is part of the process now is that analyst, which kind of takes up the time, will send what we call an unable to verify if we don't have that information. But that also can get time consuming because sometimes we're sending multiple unable to verifies because they either keep sending the wrong information or not what's needed. So that kind of ties into that question 3 about amending our fee structure, because in a perfect application, yeah, it could be an hour to an hour and a half or something. But when you're reviewing information and sending multiple letters, stating we're unable to verify this, that gets a bit time consuming for sure.
I agree. I think you definitely need to look at the fee structure, and it should be gradated on how much is going to be involved. And I think that you could be very aggressive in not giving exemptions if you can't show. I mean, if you go and you see a website and it says we offer these degrees, and then you look around and there's no description of the programs, there's no description of the courses, there's no information about the fee, there's no, I graduated, I'm so happy, nothing that makes it look like it's a real school, or things that make it look like it's probably not a real school. I mean, I think that you can say, we don't have enough information. And I think in your application, you could probably ask for more things. But again, you could also do it the other way, which is it is up to you to prove to us that you are exempt. And unless we see information showing us bona fide organization, bona fide school, you will not get an exemption certificate from us. Just one other thought. I keep losing my thoughts today. What can I say?
We're not going away just yet, so you still have a chance if it comes back. Anyone else want to comment? We're sort of moving into number 3, it sounds like, on the points for discussion. I think the only question I had on the fee issue was, it seems like a reasonable fee increase is probably warranted. I wonder, because this is voluntary, if too much of a fee increase could be a deterrent, so that unless they're required by, you know, the licensing entity or whatever to obtain the verification, if it would deter other folks from trying to obtain the verification of exempt status. That might not be a big deal, and it might be that really the main ones that seek it are the ones that need it anyway, but I just wanted to throw that out there.
And also, this is maybe just kind of jumping around, but if you're not getting a lot of complaints, it could be that the whole purpose is something other than fleecing students of money. I mean, just like we know that sometimes massage schools aren't really massage schools, they have an ulterior purpose. And it may be helpful to try to connect with the local DA's consumer section or something like that to see if they had this on their radar as to some sort of other nefarious activity, or if they're interested in taking a look.
That's a great suggestion. I think on Lee's point, the kind of that's something we thought about before also in terms of the fee levels, and to what extent do increases in fees disincentivize institutions from applying. And it's also a tricky question because, again, if we're thinking about the ones that we have the most uncertainty about, and where we don't quite understand why they so need or want our piece of paper, maybe that's not a bad thing, right? I mean, and that's where I think this notion of some sort of potential, like a varied fee that's based on the exemption that kind of allows for the ease of access for the kind of easily verified institutions, but supports our staff ability to do more of a rigorous investigation for the others. Maybe that's not a bad thing.
Yeah, that's what I was thinking. Is if you're getting the opportunity to review these folks, you might want to keep that. It's in some cases at least. And I think one thing that would be helpful, and I feel like oftentimes what I'm saying is like, give us more information, and I know that requires a whole lot of work as well. But looking at like what is the workload associated with each type of exemption, and are there exemptions that are more burdensome than others, or as in the memo, the multiple exemptions for one institution, I could see, it'd be a per exemption fee or something like that. I'm not entirely sure why an institution needs 2 exemptions anyway, unless it's like a backstop in case one doesn't work. But anyway. All right. Any other comments on section 3 or discussion point 3 or the fees? Do you want to move on to 4?
Yeah, that's great. I think 4 and 5 we've started to touch on as well. But basically we're asking to consider defining what it means for an institution to be sponsored, and also what it means to be bona fide. Some ideas that possibly could be parts of that definition. As far as sponsored, an institution pays all the institutional charges for the enrolled student. Does the institution design or approves the curriculum that they're actually offering? The institution relies on the institution's educational programs to confer the status within that organization, meaning if the graduate of that program is eligible for specialized status, treatment within that organization, potentially. And thinking about bona fide, potential aspects of that definition could be registered with the state of California or IRS. Evidence of the organization's widely accepted within the field. That membership is narrow and significant. Basically, not anyone is just going to be able to join for a small fee. That's an example of things we've seen. Documented activity. I think Margaret talked about that. Like, is there a calendar of events, evidence that things are occurring, hosted or by members of that organization? And is there a minimum number of individuals are represented by the organization? So I don't know if there's any more comments about those potential two definitions that we could add to.
This is Margaret. I think those are all good suggestions for what the kind of things you would consider whether an organization is both bona fide and sponsored, actually. In number 4, though, the way that it is written, to me, I thought the question is, the organization pays all institutional charges for enrolled students. B, the organization designs and approves the curriculum. Or C, the organization relies on the institution's educational programs to confer status. It's confusing to me that it says the institution does these things, because I thought that should be the organization.
I treated that as a typo.
Okay, that's
I don't know.
I think that's correct.
Yeah, I do too.
Yeah. But I think those are all good suggestions as to things that you can look at to see whether, this seems bona fide or not.
Great. I think I'll move on to 6, unless there's anything else. Exempt institutions or entities posing as exempt institutions do not need to comply with the Act, and the Bureau is not empowered to address false or misleading statements made by these entities. False and misleading statements encountered include claims regarding the entity's status with respect to the Bureau, accreditation status, program types offered, graduates' employability, future eligibility for licensure or certification. How should the Bureau handle situations through application consideration or beyond?
I think this is another area where we might want to consider statutory changes. This issue has come up before, that the Bureau doesn't have, when I was asking for certain disclosures, that the Bureau should disclose, hey folks, we don't regulate these short programs. The answer was, well, the Bureau doesn't have authority. And maybe we need some statutory authority so that the Bureau can make clear what it does and doesn't confer. And can, if somebody is not a school and representing themselves as such, we're trying to represent that, because they have an exemption status, it means they're in good standing with the Bureau, that these things are untrue or misleading. The Bureau should be able to take action on those. But I think that's something that we should look at statutorily, whether the jurisdiction needs to be slightly revised to deal with this kind of thing.
Yeah, I felt similarly, that I thought a legislative change might be required. I think to the extent that the Bureau can, through its regulation, consider false and misleading statements as part of sort of what we were talking about before, as a failure to provide adequate information to verify the exempt status. I think that makes sense to the extent that the Bureau can actually pursue any enforcement. It sounds like that's not possible. One thing that came to mind, I think, especially in the memo, it mentioned something about the institutions holding, using school or university or college or something like that in the names. In Business and Professions Code, there's a section that prohibits an organization from using the term legal aid unless they are actually a legal aid, and then there's a private right of action that comes after that. I wonder if, again, statutorily, that's a statutory change, but I wonder if there's something that could be done with exempt institutions not using certain language to hold themselves out as something that they are not. Anyway, that was just one thought that came to mind.
I think this also ties in with comments we had earlier. I think it would be helpful if the Bureau had on its web page right from the get-go, this is who we regulate. These kind of schools we approve or disapprove. These we don't have anything to do with. So these, we're not protecting you if you're going to, one of these other schools because they're not under our jurisdiction. I think that information on its webpage would be helpful. Probably you don't get that many people that see it, which is another question I have about how many people do go on the webpage. And hopefully you'll be able to come up with some stats on that. But that is one possibility too. The other thing is, again, here's where working together with local consumer prosecutors could be helpful, because they can certainly go after those unfair and misleading statements.
Margaret, a quick question, just clarification. With that potential idea of posting some type of explanation or definition on our website, would you go as far as listing the verified exempt institutions?
Well, it gets very complicated and confusing. So, I mean, I think a general statement saying, while we regulate some private school colleges, we don't regulate them all. Here are some examples of ones we don't regulate. And then you could list, continuing education, some of the more simple ones, and you can say, and others that, whatever. You may not want to make it so complicated that people's eyes glaze over, but at least have some kind of a thing saying, just because, we regulate private schools, we don't regulate all of them. And then you could also have something about, you already do list those that are not approved, I think, are required to on your website, but say, here you can go and see the ones we do approve. If they're not on this list, either they're operating illegally because they're unapproved, or they have an exemption and we don't have control over them. I mean, some kind of a general statement that would be reader friendly would be helpful. And then you might under that say, if you want more details, here's the things we don't regulate.
Thanks. Well, that's the end of the discussion questions. I'm definitely open if there's any other comments or information you'd like us to take back. Otherwise, thank you for your feedback.
I really appreciate how the Bureau these days is providing these memos and laying out some of the issues you're facing. It is very helpful for us on the outside looking in and not being as familiar with them as you are to understand what the issues are and then try to help you deal with them. Thanks.
I also wanted to thank everybody. Being a newer member, I'm doing a lot of learning and absorbing, and the conversation has been great, and the information very, very thorough. So thank you very much.
Thank you.
Any other comments from committee members? Okay, then I believe we will open item 7 for public comment.
We are now accepting public comment on item 7. If you would like to make a comment, please type the word comment in the Q&A box in the lower right-hand corner of the screen, or simply raise your hand. Dial-in users, please dial *3 to raise your hand. And it looks like our first request for comment comes from Grant. Hold on just a moment. We're going to send you a request to unmute your microphone.
Hello?
Hello, go ahead, please.
Okay, great, thank you. First a comment and then a couple of questions. One of your speakers mentioned that this has particularly to do with exemption status. One of your speakers mentioned that a number of schools are publicizing their exempt status on their websites. I belong to a school that does that. The reason we do that is it's the only way for us to publicize that we're operating within the regulatory framework with an exemption. For whatever reason, the BPPE, at least the last time I checked, will not confirm whether they've issued an exemption finding for a school or not, which seems to cut against the grain of a consumer protection. So that's a comment I make, and the question is, why won't the BPPE verify or not verify whether they've issued an exemption? And the secondary question is, at least on our letter, there's an expiration date for the exemption. Is that a regulatory thing, or is that something that the BPP is?
Thank you. As a reminder, we can't respond to questions during this meeting, but you're welcome to submit your question to bppe@dca.ca.gov, and Bureau staff will respond as appropriate.
Okay, thank you so much. But just a question for the hopper for you guys to consider down the line. Thank you.
Thank you. Any further public comment?
Our next request for comment comes from Nicolette Del Placio. Forgive me for your last name. Hold on just a moment, please.
That's a great attempt. It's Del Palacio, but thank you so much. Good afternoon. Nicolette Del Palacio here, representing the Institute for College Access and Success, also known as TICAS. We are a nonprofit, nonpartisan group working across two main portfolios. One, making college more affordable, and two, ensuring the quality of college programs, all centered around advancing racial and economic equality. Just wanted to thank the Advisory Committee for the very thoughtful and informative presentation and discussion on item 7 regarding exempt status verification. We just hope that the Bureau will continue to report out information on this exemption, such as who's filing for it, who these institutions are, the bona fide trade, business, or fraternal organization that they pertain to, and whether or not they're being overseen by any board, bureau, or commission in the state of California. Moving forward, we'd just like to ensure that this exemption is not being abused and that the Bureau is working so that all of these exempt schools are not accessing any Title IV funds, including also Title 38 Veterans Financial Aid Programs or any other federal aid dollars in addition to California Cal Grant. Lastly, we'd like to seek some clarification on what the process is for schools who may be advertising, claiming, or implying that it has been approved to operate by the Bureau, which some of which has been discussed today. So we thank you for that. Or if the school has been exempt by the Bureau without filing for exemption. So any information on how to follow up with those schools or programs would be helpful for students and consumers. Thank you so much.
Thank you.
And those are,
sorry.
my apologies. Those are the only requests for public comment we have at the moment.
Okay, then we can close public comment and move on to agenda item 8, which is future agenda items. From the committee members, is there anyone who would like to comment?
I think there's a few things we discussed today that would be good if we include in future topics. One thing is I'd like to have a timeline on when the additional categories for complaints or disciplinary actions are going to be added under the new IT program. We've talked about it in the past, and I just kind of like an update of how that's going and when we might see those changes. And maybe some feedback on the concept of including more information about BPPE's jurisdiction on its website, either or FAQs or something on its main page so that it's clear who does and doesn't come under its authority. And then also, I think Lee had mentioned earlier, which I think would be good to include, is if we could get some staff feedback on how the STRIF portal is working. That would be nice. And in connection with the complaints, I know you do a 3-year comparison, but that's really comparing the pandemic years to this. And not as a continuing reporting thing, I don't want to put more burden, but just maybe as a one-time thing, if at the next meeting, there could just be a comment about how the number of complaints compares to pre-pandemic. I think there were more complaints in 2019 and 2018 than there were in, say, 2020, 2021. So that might be good to see, so we can see how the current level is tracking with that. And then I think Joseph had mentioned that maybe we could do kind of a postmortem on what lessons have been learned from Silicon Valley, if any, to try to avoid that kind of disaster in the future. I'm assuming you've looked at what was done, what wasn't done, and maybe if you have any insights about anything that you have already changed or would plan to change that might make that less likely to occur in the future. And thank you very much. I mean, I really appreciate the amount of information we're getting, the thoughtful memos we're getting. It's really very helpful.
I second that. Any other committee members have items to add? Okay, then I think we can open item number 8 for public comment.
We are now accepting public comment on future agenda items. If you would like to make a comment, please type the word comment in the Q&A box in the lower right-hand corner of the screen and send that comment to all participants. Dial-in users, please dial *3 to raise your hand, or anyone else for that matter, raise your hand. And we will take comments in the order we have requests. We're going to give just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
Yes, please. And the next item is adjournment. So with nothing further on our agenda, thank you all for bearing with us. This was a longer than normal meeting, and thanks for being patient with me as I navigate my last two agenda items. And thank you again to all the Bureau staff for all the work that you put into this and all the information you provided. And I would just note, actually, no, I won't. I think that's everything for today. And we will see you in August.
See you in August. And as a reminder for the committee members, that meeting is slated to be in person. We decided that, as you heard earlier, we will likely, the rules under which we are currently operating for virtual meetings will no longer be in effect, but we decided anyway that it would be nice to occasionally meet in person. So that meeting is scheduled to be in Sacramento in August, and all the full information is on our website. And just thank you, I think from the staff, thank you for all the comments and all the feedback. We've got a lot of things to think about after this meeting. And also just thank you for the appreciation that you've shown for all the work of our staff and leadership. I know they are working very hard, and it's wonderful to have that recognized by you all. So thank you.
Thanks, all. Everyone go get a drink of water.
Thanks.
Have a good day.
Thank you. Bye-bye.
Bye.
Bye-bye.